This is Rick Frederick with a review of Durham v. U.S. 1954 case. D.C. Appellate Court, not a state case, not a U.S. Supreme Court case, a district court case, the D.C. District Court. This opinion written by Judge Bazelon, who is well known as a champion of rights of the mentally ill. You can go to the Bazelon Center in D.C. My understanding is that his sister was a psychiatrist. He was very knowledgeable about mental disorders. Here's a case of a career criminal, essentially, Monte Durham. Long history of arrest, imprisonment, kicked out of the Navy for unsuitability, and had just recently been released from St. Elizabeth's Hospital. If you read the prosecutor's colloquies with the court, you see that he just is tired of this revolving door policy of St. Elizabeth's, where Durham appears to get sent to St. E's and then gets kicked out of St. E's and then goes back and continues his criminal conduct. In this particular case, he'd been found incompetent to stand trial, readmitted to St. E's. He was tried without a jury, presented a defense of insanity, and the test at that time was a right-wrong test, supplemented by an irresistible impulse test. A psychiatrist testified that Durham was of unsound mind, but the judge ruled that there was no testimony on Durham's mental state on the date of the offense, and therefore the defense had not overcome the presumption of sanity, which would have then pushed the burden to the prosecution. So essentially, the part of this discussion was about burden of proof, standard of proof, and Bazelon's frustration with a limited idea of insanity. So, did the trial court err in applying the rules governing the burden of proof in a defense of insanity, and should the existing test of criminal responsibility be replaced? Again, where's the jurisdiction for this? This is D.C. So this is going to be rules that apply to D.C. and any courts using stare decisis to then bring it into their jurisdiction. But it's a D.C. District Court. It's a D.C. issue. The D.C. Appellate Court held that the trial court incorrectly applied the rules governing the burden of proof. His conviction was overturned. He was sent for a new trial, and that the existing test of insanity would be new, or be replaced as obsolete and replaced with this new product test. Now, if you want to know the product test goes back to Pike in the 1800s, a New Hampshire case, and it was essentially a rule used by New Hampshire. So, we're going to talk about what the product test is, but it wasn't a new concept. It was simply a concept that was going to be included in D.C. cases from here on out. The appellate court pointed out the defendant must present only some evidence to shift the burden and to consider the whole evidence. So they're really sliding the judge here for saying, look, there was no evidence of insanity on the day of the crime. Well, that was far more than some evidence. That was too restrictive a view. And it gave the Durham court this opportunity to talk about a new standard. What's great about the Durham case, I don't think anybody really wants to argue that the Durham decision should be embraced, and it was later reversed by the D.C. Circuit Court, but it was a great review of case law forming insanity defense. It's an excellent read. Um, the right-wrong test is too restrictive, failing to take a sufficient account of psychic realities by focusing exclusively on one symptom of mental disorder, which is cognitive. The irresistible impulse test, which was also part of their standard at that time, was also considered insufficient. A broader test was necessary according to Bazelon, and so they adopted tests similar to that used in New Hampshire, that an accused is not criminally responsible if his unlawful act was the product of a mental disease or defect. Now, this idea, I want to get to some quotes here, but basically, this is Bazelon standing on his pulpit saying there is a broader view of mental disorder than has been embraced by the court. So we'll find out later that it's just a nasty mess that could not survive and did not survive very long, the Durham rule. Okay, so just some quotes that are interesting in this idea of what is mental disorder, what should be considered by people looking at culpability, criminal responsibility. 9 years ago, we said the modern science of psychology does not conceive that there is a separate little man in the top of one's head called reason, whose function it is to guide another unruly little man called instinct, emotion, or impulse in the way he should go. So the idea that you can extract out simple elements of intellect or emotion or behavior and say, look, a psychiatrist, psychologist has to focus specifically on this one little person is ridiculous. Going back just again, and what are the developing ideas of mental disorder? Everyone concedes that the present legal definition of insanity has little relation to the truths of mental life. Here, this was addressed by a justice to a convention of doctors, saying we know that it's more complicated, and so Durham is about, look, mental life is complicated, and we should have a broader brush to paint what is responsibility or not. So the rule we now hold is simply that an accused is not criminally responsible if his unlawful act was the product of mental disease or mental defect. Now, what is a disease? It's a condition which is considered capable of improving or deteriorating. We use defect in the sense of a condition which is not considered capable of either improving or deteriorating. May be congenital, may be the result of an injury, may be the residual effect of physical or mental disease. We'll get into the Bronner case, ALI, other ways to conceive it. And it's very interesting to compare Bazelon's writing with something like the Supreme Court of the state of Idaho in upholding Delling v. Idaho, in which, or upholding Idaho's rejection of the insanity defense. Very different views at the extremes. Thank you very much.